On the 27th of December last year, the Commission sent you a request for submission of the 5-year declaration of assets and personal interests. On the 2nd of January this year, you submitted your 5-year declaration. The Commission also asked then candidates to voluntarily complete and submit an ethics questionnaire, and you did so on the 1st of July last year. The Commission sent you 3 rounds of questions on 14 February, 23 February and 27 February respectively. You were asked a total number of 25 questions, including 105 subparts, and 50 of the questions included a request for further documentation. The Commission would like to commend you for the expeditious and detailed information you provided the Commission to all our questions. According to Article 3, Paragraph 4 of the evaluation rules of the Commission, a candidate may not provide information, documents or other materials during the hearing if the Commission requested these earlier and the candidate did not provide them within this time specified, unless of course the candidate provides sufficient justification. Members of the Commission will now start with asking you questions, and I will start with asking questions first. We will try to keep our questions short and to the point, and we ask that your answers be short and to the point as well. So let me start with asking questions for you. We have 2 issues we would like to raise with you, and the first one relates to the purchase of a car, an Audi Q5 model in 2020, and a donation from a friend. So the facts are the following. On the 6th of August 2020, you became the owner of a car, a model Audi Q5, which was made in 2014. This purchase was done in exchange of a car model Honda CR-V made in 2006. The selling of the Honda and the purchase of the Audi took place via a power of attorney, and the Audi Q5 was imported from Canada in November 2019 and required some repairs. The sale purchase contract of 6 August 2020 indicates a price of 90,000 lei. However, the actual value of the car after repairs amounted to 17,000 euros. This price was about 9,000 euros higher than the value of the Honda. Asked by the Commission what repairs were required, you indicated that some slight damages had to be repaired, but that you don't have any further information on what needed to be replaced, and that the value of these repairs were included in the total price for the purchase of the car, and all the expenses were fully paid by the seller. This difference in value was covered by a donation of a friend of yours. In the annual declaration for 2020, you indicated the purchase price of the Audi Q4 to be around 70,000 euros, which at that time was around 340,000 lei. And on December 2021, you sold the Audi Q5, also via a power of attorney, for the price of around 16,000 lei, or 16,000 euro, which at that time was around 320,000 lei. As this sale price by the end of 2021 was lower than the purchase price in August 2020, you did not pay any taxes over capital increase. You provided to the Commission a copy of the power of attorney for alienation of your Honda CR-V in August 2020 and the 2 copies of the sale purchase contracts in 2020 and 2021 for the purchase and sale of your Audi Q5. You explained that the transaction of 2020 was an exchange one. You sold your Honda CR-V and purchased at the same time the Audi Q5. You didn't have documentation relating to the price or nature of the repairs made to the Audi Q5 model. You provided to the Commission a signed statement by your friend in which he indicates that he was aware you were interested in replacing your old car and that your friend was in a better financial situation at that time and that he decided to contribute financially to the purchase of the Audi car as a sign of gratitude for your friendship with him and for your help to him for 10 consecutive years. He also indicated that this financial contribution was not a payment for provided services. You declared the donation of about 9,000 euros from your close friend in the annual declaration for the year 2020 and the 5-year declaration that you submitted to the Commission, and you described it as a contribution for purchase and reparation of Audi Q5 model. In your annual declaration to NIA for 2021, you declared the income from the sale of this car to be around 320,000 lei. When asked about the ability of your friend to pay for the donation of 9,000 euros, you provided documents relating to the annual declaration of this friend for the period 2019-2020, when this friend was required to submit such a declaration. Based on this information, it was apparent that this donation would not be a burden on his financial situation, so that you considered yourself to be able to accept the donation. I now have a number of questions for you. First, to clarify and confirm the facts as I just read out, and then we will go a bit more into the detail. My first question to you is, can you confirm that you bought an Audi Q5 in August 2020 for the total price of 340,000 lei?
Yes, I confirm that in 2020, on the basis of a trade-in transaction, I became the owner of an Audi Q5. Therefore, the total value of that procurement was 17,000 euros. So there was this complex transaction, the trade-in transaction. It meant that I gave up the rights on the car that I already owned, and the rest of the procurement was covered by my friend that, as mentioned in the previous declarations, he had this possibility. And also, he was the client, the direct client of the car dealership that was importing these cars.
Okay, thank you. And can you confirm that the car was slightly damaged when imported in November 2019 and that some repairs had to be made?
I can confirm that when it was purchased, the car was in a good condition. That is, out of the statements what the car dealership owner said, and he showed that to me, and I also had a look at the VIN number of the car. I looked into the importation procedure from North America, and as well, we could confirm that there were certain issues with the car. However, the body issues that it had, and as for the amount required to fix them, I don't know about that for certain. I know the total amount, that the final price that had to be paid, considering that the car was also on the 999.md car sale platform, and there was the price 17,500 euros, and we've had negotiations, and we agreed on 17,000 euros.
Thank you. And can you confirm that a friend of yours donated in total around 9,000 euros to you to purchase this car?
This amount that I also mentioned in the declaration that I declared as a gift, it was indeed paid to the intermediary. So it was not given to me for me to pay them this amount to the car dealership, to the intermediary, that is. But as I said in the declarations and in all the other written documentation that were submitted during the Q&A sessions and rounds, there was enough proof provided, enough evidence to show that my friend was in charge of all the formalities regarding the procurement of that car.
Okay. And can you confirm that in December 2021 you sold the car for the price of around 320,000 lei?
That is correct. In 2021, in December, I decided to get another car. Using the same transaction, the same procedure, I found another car, and I made this exchange, the sale, and then the procurement of another car.
And your friend submitted a written statement according to which he confirmed this donation and that he was in a better financial situation at that time. Your friend had more than enough financial resources to pay for this donation. That is correct? Yeah. Okay.
That is correct.
Your friend also stated that he decided to contribute financially to the purchase of the Audi car as a sign of gratitude for your friendship with him and for your help to help him for 10 consecutive years. He also indicated that this financial contribution was not a payment for provided services. Can you explain what kind of help you provided to him during these 10 years and why it should not be seen as a form of payment for services provided?
So first of all, I would like to mention that we are sort of family friends since back in 2010, and throughout this period of time we've indeed had a very close friendship relationship. And in 2020, right before my birthday, I'm born in August, and as he knew that I wanted to have another car, a new car, to get another car, he offered to contribute in that way to the procurement of another car. And according to the declarations that I've already submitted, he had enough funds in that year, and in addition to that, he was a loyal customer of that car dealership. So it was not a problem for him to make such a birthday present to me, even with that price difference. And I would also like to mention that according to the my income returns that I also submitted for 2020, I had enough funds. The net income, well, he had enough funds, and the net income of that friend was more than 200,000 lei. So it was not a problem to provide the contribution. However, just to make it transparent, to make the procurement process transparent, and also considering the explanations of my becoming an owner of that car, I decided to explain the circumstances well, important for certain decisions to be made. So I would like to highlight, it was not a problem for me to purchase that car. It was not a problem for me to provide the 7,000 or 8,000 euros. So it was not a problem for me to then also accept this gift that I declared.
Okay, thank you. What steps did you take to assess whether the financial means your friend was able to use for the donation to you came from legitimate sources?
If I'm not mistaken, in the fourth round of questions and answers, I also provided the declaration, the income declaration of my friend. And he is a public person, he is an artist. And that confirms that he actually had revenues more than, well, that exceeded millions of lei. So I believe that I accepted this donation because he declared his income, so I did not see any problem whatsoever with that. Everybody knows that we are friends, and I have really nothing to hide.
Is there, in relation to this issue, anything else you would like to clarify or add in relation to this issue?
I would like to mention, since this question also had to do with the capital gain, I would like to underscore the fact that, according to the government decision 1046 of the 8th of November 1999, on the organization of the informational system, the automated information system on cars, there is the point 21 of that government decision that sets out what the records, how the records are to be kept on cars that are registered in Moldova. So if you look at point 21 and point 40 in C and F, you can see what are the ownership types, how you can register ownership rights on cars, on vehicles. And so for the ownership rights to be registered, well, that requires to have a donation contract or an exchange contract or a contract on the exchange that is notarized, or F says that it has to be a standard contract for sale and purchase according to Article 210 of the Civil Code. So in order to establish the size of the capital gain according to Article 40 and 42, we need the value basis of that, and that means the assets, the capital assets. So considering that in August 2020 a trade-in agreement was entered into, and that is also provided for in the Civil Code as a typical complex agreement, on the other hand, the government decision 1047 is not aligned with the provisions of the new Civil Code, and therefore, at the time when the ownership rights were registered with regards to that car, what is kept is going to be one contract only. And I presented to the Commission that there were actually several agreements, several contracts, and the sole fact that if you look at the archive of the Public Services Agency, a contract was retrieved that was shown to you, and you were able to compare it against other types of contracts. At the end of the day, it was a standard type of a contract, so it was not possible to make the registration procedure. So it is little likely that judicial processes can be launched to oblige to force the registrators to register a complex atypical contract. And that's for the intermediary company, that services of which I use. And you asked me about why I accepted the procedures like that through the notarized, through the powers of attorney. It was because at that time that register for chemical records of the cars was not in line with the provisions, was not aligned to the provisions of the civil code. And therefore, I believe that the matter about the transfer of the ownership rights to me in 2020, I think that is a matter settled. And as regards the presentation of other copies, I would like to underscore that once the car was alienated in 2021, I did not believe it was further required to keep all the receipts or all the other pieces of evidence with regards to that transaction and to that car.
Thank you. Anyone else with the colleagues? No? Okay. Then let's move to the second issue that we would like to raise with you, and that relates to the building of a guest house in Resina district and the management of that guest house by a company of your wife. So the facts are the following. In 2006, you bought a land plot with a construction on it in a touristic zone in the Resina district. We don't mention any further details for privacy reasons. And the price at that time was 30,500 lei. You were able to purchase this property as a result of the money received at your wedding in 2006. You provided the Commission with a copy of the sale purchase contract for this property. On 29 September 2010, your wife became the owner and administrator of a limited liability company that, for purposes of a hearing today, we refer to as the DS Company. The company was created for tourism-related activities. According to information available to the Commission, the company did not create any income or net profit over the years 2010-2020. In 2016, according to your ethics questionnaire, you obtained a permission for the construction of a guest house and on that land plot. But you also informed the Commission in the first round of questions that the actual construction works seem to have begun in 2015. You provided to the Commission detailed overviews of the construction activities and costs involved. From this overview, it appears that most construction activities took place in 2017 and 2018, and that most costs were also incurred during these years. These costs related to such activities as the demolition of a house on that property, excavation works, building of the walls, installation of windows, laying of the roof, etc. You informed the Commission that these costs amounted to a total of 430,000 lei. According to a final reception report of 10 November 2018, of which you provided a copy to the Commission, the building was put into operation as of that date, although in the course of 2019 and 2020, some finishing and decoration works took place, such as interior works, furniture, kitchen equipment, etc. You informed the Commission that as of 2020, the property could be used for accommodation. So the property now consists of the land plot, the guest house of 555.9 square meters, and an auxiliary construction of 11.2 square meters. In 2018, you signed a bailment contract with the DS Company. You shared a copy of this contract with the Commission, and according to this agreement, the DS Company received the property of the guest house free of charge, but you undertook to provide for the investment costs in the amount of 517,000 lei. This was not a money loan, but a payment in kind, so to say, and that you bought the construction materials for the construction of the guest house. The bailment contract transferred the ownership of the property plus the building materials to the DS Company. In return, the company has a debt of the same amount of 517,000 lei to you. In 2020, you provided a loan of 110,000 lei, and in 2021, a loan of around 270,000 lei to the same company. So in total, the DS company has a debt of around 900,000 lei to you. These figures are confirmed by a statement submitted by your wife as administrator of this company, and of which you also provided a copy to the Commission. In addition, in January 2021, you signed a lease agreement with the DS company relating to this property for the duration of 10 years. According to information from the National Bureau of Statistics and the fiscal report provided by you, the DS company in fiscal year 2021 has a total current debt of nearly 1.1 million lei and had an income from sales of just over 120,000 lei. You also informed the Commission that you did not take any loans from banks and natural persons, as your income over the relevant years 2017 to 2021 was sufficient to pay for the construction costs and the loans to the DS company. So now we get started with the questions. The first question again is, can you confirm that you bought the plot of land and construction in Rasina district in 2006 for the price of 30,500 lei, and that you were able to purchase this property from the donation to you and your wife at your wedding?
Yes, indeed, I confirm. In 2006, after our wedding ceremony, given the financial resources, we had around $1,700 to buy that land plot, including the constructions that were located. It wasn't just one. But I mentioned that it wasn't only the land, but also the constructions and construction materials there.
Yeah. And can you confirm that the DS company was established in 2010, and can you confirm that in the period 2010 to 2020, this company had no income and no profit, and can you explain why that is the situation?
Yes, indeed. In 2010, Delia Star Company, which was established by my wife, had she had the intention for us to perform some activity, including in the field of tourism, and unfortunately, it wasn't my wife's favorite area, so we were not very active. Only when we had more financial resources, we started to work and invest. So we wanted to have a tourism destination. Moreover, if you looked into the statistics in the statistical reports, indeed, revenue started to be collected only after our family ability to build this guest house was strengthened.
Next question is, can you confirm that you were issued a building permit for the construction of a guest house on this property in 2016, but that it seems that some construction works already started in the course of 2015? If so, what kind of activities took place prior to the issuance of the building permit?
Indeed, as I mentioned, so in 2017, most construction started, but there were already two constructions on the territory, and until 2016, that was used as like a summer house for my family, for my friends. It was so one of the constructions was used as a summer house. In 2015, indeed, we obtained a construction authorization according to a new construction technical design. So therefore, in 2016, we started the reconstruction of that building. Moreover, I submitted the authorization to demolish one construction that was located there and reinforcement of another real estate that has the total area that you mentioned. So until 2016, on that land plot, there was the summer house, a vacation house of our family. What we did after 2016 and 2017 was to adjust the parameters of the building and to increase its area.
In the course of 2017 and 18, you invested a total of 430,000 lei in materials for the construction of the guest house. According to the bail agreement with the company in 2018, the company was indebted to you to a total amount of 517,000 lei. Can you explain the difference between those two figures, the 430,000 lei and the 517,000 lei that forms part of the bailment agreement?
I'd like to highlight that the amount of 517,000 lei was put under account 522.1, which is construction material and services. These materials and services were done on the account of the undersigned. So during the years of 2017 and 2018, and as a result of the bailment contract, and in 2018, when this new building was put into operation, Delia Star company assumed this investment as a debt for the investment, given that the bailment agreement meant the free of charge use of this guest house by the mentioned company. Therefore, it was not an amount that I lent to them. I was invited to mention what the construction works were during 2017 and 2018 based on the invoices that were reanalyzed and took into account. So that's how I reached the amount of 430,000 lei. That was the amount for purchasing materials and services in 2018, which I reported appropriately. And the remaining part, that was around 80 to 90,000 lei, they were expenses made in 2017. Therefore, we cannot say that the total amount of the loan was 517,000 plus 430,000, because the 430,000 are part of the 517,000, and it wasn't a loan agreement. It was a debt that was taken under account 522. So I submitted the financial statements, the agreement, including the contract that highlights this transfer of debt for the purchase of construction materials. Moreover, the bailment agreement provides an extra guarantee to the company, given that the company becomes the owner of that investment. And in the end, it's a situation where that's a win-win for both sides. For me as an investor who obtains an account receivable worth the investment made, and the company that becomes the owner, as we can see, until 2031. This is the term of contract. They become the owner of that investment. So, and if the agreement is terminated, the company will have to win as a result of the enforcement of this account receivable, and the other way around.
Thank you. And can you also confirm that in 2020 loans were provided of 110,000 lei, and in 2021 270,000 lei to the company?
Indeed, in 2020, the work of this guest house started. At that time, the company, I don't remember, I think it had 3 employees, and given that that was a pandemic year, the flow of clients dropped significantly. And as it was mentioned, I provided the business plan also. The expected results were not achieved, therefore an investment was necessary from the spouses. Given that I had more income, I was the one who was the investor in the end.
And the 27, that was for both the 2020 loan and the 2021 loan?
Well, these were some periodical payments, and I think I provided to you, and you saw all the transfers from my banking card. You saw the amount of the loan according to the loan agreement. So So from a certain period of time, first of all, when taxes needed to be paid, including social contributions, medical insurance for employees, for services, and so on. So I was transferring to the account of the company, and then the company was paying taxes to the state.
And did you make any other costs relating to the establishment of the guest house that did not form part of the bail agreement of 2018 and the loans provided in 2020 and 2021?
The construction costs, obviously in some smaller amounts until 2015, they were not significant to the extent of our possibilities. After 2018, we preferred to make official every expense for construction. So everything was based on that loan agreement, and all costs for the maintenance of the construction, for reconstruction, for furbishing are incurred by Delia Star Limited Liability Company, either through what they collect through provision of services, or if no resources are not enough, it's money from the associate. That's my wife or me, the other side. So there was also some investment projects that the company won. It was possible to upgrade this guest house, and that actually continues now.
And can you confirm that the total debt of the company in fiscal year 2021 amounts to 1.093 thousand lei, so nearly 1.1 million lei, which is more than the total amount of the 900,000 lei debt the company owes to you. Can you explain the difference between the 900,000 lei and the nearly 1.1 million lei?
According to the information at the National Bureau of Statistics, that is the amount of their total debt. There are other partners or companies that the Delia Star company owes money to. And I also mentioned that this company was the beneficiary of several investment projects. So this amount includes some debts for goods that, and they owe money to other people, not only to me. So towards me, they have a debt of around 900,000 lei. But there are other companies, people. I'm not managing this company. I don't know exactly who they are.
Thank you. And can you also confirm that the income of the company in the same year, 2021, was 120,000 lei, and what this income consisted of?
These sale revenues were for organizing events, renting rooms during summertime. That tourist destination is used by many tourists, nationals and foreigners, and this is the amount that they collected during 2021, which, as I mentioned earlier, was affected by the pandemic and other things. And therefore, well, it was not in line with the business plan, because what we planned, the amount was supposed to be much higher.
Through the bailment agreement of 2018, you transferred the property of the guest house to the company. But in 2021, you signed a lease agreement for the same property with also the company. So how does the bailment agreement where the property was transferred relate to the lease agreement where you lease out the property to the company? Who is now the owner of the property?
The owner is still me, because I did not alienate this property. For a more efficient management of a property, to ensure the sustainability of investment, including based on projects that were successfully implemented by this company, the main condition of the investors was for the good to be leased for a period that is at least 5 years. And given that I have no possibility to manage as an individual, to manage this real estate. And given that this company has some individual activities regarding, including relationships with various business partners, clarity is needed, of course, about the future use of this property. Therefore, it was decided to sign a lease agreement for a 10 years period that was registered appropriately with the cadastre back into 2021. Otherwise, I mean, it's clear, since this is a rural tourism destination, without a lease agreement, it's almost impossible to have a limited liability company perform activities, including receiving certain subsidies that until now they were not able to apply for them because there were no sales. But as this business develops, there will be questions about who is the owner and beneficiary of this.
Can you confirm that you did not take out any loan from a bank or other legal or natural person in relation to the investments made to the guest house? And can you clarify how you were able to make these investments?
Yes, sure. During 2018 to 2021, my net income was around 5.5 million lei. Therefore, it was not a difficulty to provide some loans, and even in the total amount of 900,000 lei for a business that, in the end, belongs to our family.
Is there then anything else you would like to clarify in relation to this issue?
No, nothing.
I'm looking around at my colleagues. Are there any other questions? Please go ahead.
Hello, Mr. Postica. You mentioned the lease agreement, but do you get a monthly payment or annual payment, and what's the amount that you get from the company? Indeed, according to it's not free of charge. It means a payment of certain amounts. The lease payment is 1,000 euros. You have a contract in front of you. Moreover, the contract provides that this payment can be provided in kind through investment. The same mentioned in the same contract. And given that in 2021 we had the pandemic, in 2022 we had, and we still have, a war. Given the location of this property, which is in Rezina, the security area, of course the expected profit was not achieved. Therefore, by now I did not ask for any payment to be made. Moreover, I would like to inform you that based on the agreement, gave up on the payment for this period of time because of the state of emergency that we currently have.
Any other questions from any of our colleagues? Okay, then that will come nearly to the end of our hearing. I would like now to give you the opportunity to make a closing statement. Please go ahead.
I can only thank you for your attention and treating my questions. Thank you for interesting questions that make you think and reassess the way you manage your money. In the end, that was a beneficial exercise, and I wish you good luck in your activity.
Thank you very much. With this, we come to the end of the hearing. I would like to thank you again for being with us this morning and answering all our questions today, but also in the written procedures. The Commission will now withdraw for deliberations, and as much as possible, we will strive at delivering a decision within a month after the date of this hearing. I hereby declare the hearing closed, and thank you again for being here. Thank you.